Good morning, ladies and gentlemen, committee members. We can be here as long or as short as you want to, but I do think this is a good opportunity since this isn't a normal day in session to maybe get caught up on a few things. Some of them that we aren't going to act on today, but maybe something that was very interesting to the committee this year. We do have a couple of bills. First one we're going to go over is House Bill 779. Representative, would you like to come on up? We're going to discuss this. We have another bill we're going to discuss, and then I'm going to talk about the process of a issue that we've had on the committee this year with the transportation referral companies. The one that everybody's been beat around the head and ears called Uber. I'm going to give y'all an update on the process of Uber and the such. All right. Do y'all have a substitute in front of you for House Bill 779? Are you working from 0599S?
Yes, sir.
All right.
Thank you, Mr. Chairman and ladies and gentlemen. I bring before you the substitute to HB 779. What we originally had changed was to strike line 25 without payment of fees and add pretty much a breakdown of where we put the burden back on the probate court judge to come in and either charge $30, which is the maximum, $22, which is what the state requires, or $1 for the probate court judge retirement. We also added in there where it was a citizen, United States Military of Georgia, National Guard, and has served no less than 3 years, and a Georgia citizen.
Righty. We have a secondary idea to throw out there, and I think I see him coming with him. I left him. Just keep that one. We've got some of these, and we'll pass these out. If you would, let's distribute these. When we discussed this bill at last time, we were looking at how possibly the dollar amount that could be waived if that was the will of the local authorities. We also cleaned up, and I notice you've also cleaned some of the language up. Yeah. I notice that we do have this cleaned up about being sure that it means that they're a citizen of Georgia.
Yes, sir. That
language, and I think the A and the B on 32 and 34 are correct too. You got another proposition that's been thrown out there that's is pretty similar to Representative Dunhu's amendment. Just some changing of the language about the $30 or that dollar amount. So it's following consultation with the judge of the probate court of the county, the governing authority of the county, that may by resolution or ordinance waive for any person. So what they're talking about this one would be basically that probate judge in consultation with the county commissioner that they can then decide how much, which might be more uniform.
Yes, sir. And I'm open for whatever that the committee decides, and you, Mr. Chairman.
All right. Well, it's what this committee wants. Anyone want to address this? You push your button, Ms. Frazier. Thank you. Ms. Frazier.
Thank you, Mr. Chairman. So we have a $30 maximum fee.
Yes, ma'am.
But the probate judge can determine up to that amount.
Up to that amount.
So I'm retired military, and I want to get a weapons carry permit license, and I go before the probate judge court. And so how will he or she determine that fee? Could it be $10?
Well, here's how I've called 40 different counties, so I've done a little research on it. I'm pretty sure there's 4 that do it free. They charge nothing.
Right.
There's probably somewhere between 10 and 12 that charge only $7 the price of the card. Then there's certain ones that charge $30 the cost. There's certain ones that charge $45 because of fingerprinting and all the other things. But I was surprised at how many. It depends on your county and your probate court judge.
So is at the discretion?
That is,
And
yes, ma'am.
but whatever it is, they cannot exceed $30.
Yes, ma'am.
Okay, I'm fine.
You'll get a break, and thank you for your service.
Yeah. Let me back up. I may be redundant. If y'all remember at the last meeting when we were discussing this, if House Bill 875 passes, that eliminates that $40-some-odd charge for the fingerprint for a renewal license. You still have to get your original license to do the fingerprints. So the process, if 875 passes, you take that hard card to go get your renewal. Then they will then do the GCIC report, which is a no cost to that. So that eliminates the charge on the fingerprints. So that takes care of what the representatives want to do on that part. So that left that $30 charge that we were talking about. Mr. Glanton.
Mine's not related to that. I have a different thing, so I didn't want to interrupt. Go ahead.
On this bill?
Yes, it's on the bill.
Go right ahead.
Okay. All right. Thank you, Mr. Chairman. I have I guess for clarification, the definition of the word citizen. And the reason I ask that, because traditionally we're citizens of the United States and residents of a state. The second thing is that military personnel, honorable discharge, may have served in our U.S. military, but may not necessarily be a citizen. They may have a green card and have yet to go through the citizenship process. So how do we address that? Because ultimately we're eliminating those folk who have served honorably in our armed forces.
Yes. And to make it simpler, I guess the answer I would give you would be, if someone in Texas is coming over here to visit their uncle, and he sees at Georgia we have a break for military license fee, this is just saying that he has a residence, he or she, in Georgia, pretty much as a citizen, that they have a residence here.
And I like the bill, you know that. That does not really address the concern and bring clarity to it. It makes it too ambiguous. It's because you're not really defining what a citizen is, and in some respects a citizen is a citizen of the United States and a resident of a state within the United States. And then a military person who is honorably discharged could very well be one that has not obtained citizenship, but by way of green card is serving in the armed forces and yet to undergo the citizenship process and oath. So I think that there's some problem there. I'm just trying to help out.
Okay.
Can anybody help me out?
Yes, sir.
Mr. Chairman, just to address it, if the author's trying to go towards residents of Georgia, it seems as though we could just change citizen to any resident.
Exactly.
Of Georgia. Let me think about it a little bit better on how that would need to be worded. But if that's what his goal is, we could possibly tweak that just a little bit to make that work.
I think when we were at the last meeting, what we were more concerned about is that when we said citizen, we were wanting someone who is a Georgia taxpayer who lives here, not someone who has a vacation home here and a permanent residence somewhere else, to be able to have multiple licenses. I think that was what our gist was, and I don't know whatever the will of the committee on that interpretation of whether you want to call them a citizen or a resident.
Thank you, Mr. Chairman. Representative Glanton raises an outstanding point on this, and he's right to seek greater definition. I'm looking on the Georgia Department of Veterans Service website because they wrestle with this issue in terms of providing benefits to veterans. And the way that they define it is that there are two ways to meet the Georgia residency requirement. First, if a veteran's military discharge certificate, DD Form 214, shows he or she entered military service from Georgia and the veteran is a current resident of Georgia, then he/she meets the requirement. Second, if a veteran has been a legal Georgia resident for the past 2 consecutive years, then he/she meets the requirement, which could be somebody that entered service from, say, California or New York or Minnesota, got stationed at Fort Stewart, Fort Benning, liked it here, and then stayed, and then they've lived here for 2 years. But that would mean that they'd have their driver's license, they're paying taxes, and they're doing the things that we expect our residents and citizens to do. So my proposal would be to add in that language, or I don't know if Legislative Council is here if there's probably a subsection of the code that we could just reference to in terms of this definition.
Follow up to what he said. And Mr. Chairman, that would address that concern in regards to them being legal residents here in the state of Georgia. Because some folk may be from Texas, but they may change their home of record or residency off of their 214 to that particular state which they want to reside in.
All right. Very good. Do you think, can y'all hastily put the correct, I'm sorry, Ms. Frazier?
No, I'm good. He answered it.
Can y'all put this language together that you and Mr. Alcom have talked about?
Yes. And is there another subcode or something that?
I don't know if it is.
Attorney?
I don't know.
All right, what's the will, Mr. Alcom, you and Mr. Blanton, what would y'all like to submit to the committee?
At the appropriate time, Mr. Chairman, I'd be happy to make a motion to include the language that I referenced, and I don't know if Legislative Council is available to help us with
Would
that.
you like to restate it? And, council is up here on the front bench with you.
There you are. Thank you. Would be to define the class of veterans who would be allowed to participate in this, that they can prove their eligibility by either presenting their DD form 214 showing that she entered military service from Georgia and the veteran is a current resident of Georgia, or if the veteran has been a legal Georgia resident for the past 2 consecutive years, then he or she is eligible for this benefit. It is from the Department of Veterans Affairs, so I don't know if this is their rule or if this is in code. Sure. Or I could just pass this down to you.
Airmail.
Technology is going to be the death of me. We'll give counsel.
Mr. Chairman, while he's looking at this, and I really don't have a problem with language here also that Mr. Edwards had provided, in your discretion there. If you think we ought to go ahead and add
Let's
that.
let council work on that. What would be the will of the committee on the proposed announcement about the probate judge in conjunction with the governing authority, since it has an effect on them? Let them make that decision. Does anyone have an objection to that, or would they like to make a motion? All right. All
I'd
right.
like to make a motion to accept it. Thank you.
We would integrate this language into the bill, and we have a motion and a second. Mr. Hightower?
Are we applying this language to LC 353025?
No.
No. Run the substitute.
0599S. There you go. Mr. Edwards, did you?
The amendment was based on the original bill, not the substitute.
All right.
It would have to be adjusted to fit into whatever is currently in front of the board.
Julius, I think what he's wanting to do is use that and add that into the language of the substitute. Originally, that was prepared for the original bill. Let's give council a couple of minutes to.
Chairman, can I help for a second?
You certainly may.
I don't think with the amendment here will work very easily in the amendment, the substitute.
Well, then
The
go.
amendment that we have, it works in the original LC 353025. If we try to amend the substitute to put this amendment in, we're gonna change a lot of stuff. It won't work as easily.
Then why don't we make it work by reconstructing that language?
Okay. The only reason I bring that up is if the author's okay with this amendment that they're offering, if we look at it in conjunction with his original bill, this amendment should take care of all the other concerns about the citizenship and defining all that stuff, because we don't have citizen in there anymore. So if we're okay with this amendment, we could very easily just alter the original bill, and all the problems would be solved without the extra work.
So you're suggesting that we go back to the original bill, substitute this language on line 23 into that subset.
Yes, sir.
All right.
And then you wouldn't have to deal with the term Georgia citizen if the author's okay. I'm just trying
Yes,
to see if
I'm
he
fine
he's
with
okay
that.
with that. If we go back to the original bill,
I'm fine
take
with
out
that.
the Georgia citizen concern, you wouldn't have to make those definitions, and it would simply be a simple substitute or amendment to the original bill.
All right. Well, let's try that on for size.
The only thing we may have to do is also add National Guard to the original bill, which is not there.
Right. Where we did in the substitute, we would just
Yes.
come to the original, put this, and then add the National Guard.
All right. You got time? Have you got it all worked out?
Not yet, so we're doing the original bill, converting this language into the original bill.
I think what they decided, if we go back to the original 779, and then we replace it, amend it with this language, and then what was the other amendment that needed to be made? We'll give him just a few minutes.
32 through 35. Add that to the substitute.
Yes, you would substitute lines 32 through 35, or you take lines 32 through 35 of the substitute and
Put it back on the
put those back in the original bill in place of lines 29 to 31.
All right. Representative Plant.
I understand what we're doing here, but how does that cover what we were trying to get with making sure that these folks are actually residents of the state of Georgia and paying taxes? How do we get there from this amendment?
Julie's got one.
It helps us with the citizenship thing, but
Right.
it doesn't help us with what we were trying to get to as far as the residency and paying taxes.
I would say if you want to make that definition, you go at the end of line 31 and put a C and do a description that
And it would,
put your citizenship, put your residence or citizenship, whichever you wish to call it, and just create a C after B on line 31.
and that would that include the requirement for residents, the time for requirement? We had 2 years.
That's where you could put it
2
in
years,
there.
okay.
Ms. Frazier?
I'm just trying to get some clarity on the amendment that Representative Clanton is trying to put in, because currently, right now, with the changes that you're about to make, it still doesn't cover what we're trying to do. So, after line 31, starting on line 32, that will stay the same in the original language, right? We're just going to move that down and insert.
I think what Representative Blanton is proposing
Yes.
is to create, after B, to create a definition that the person shall be a Georgia.
On the
Resident.
original bill, right?
Original bill.
We're not talking about the substitute
No,
anymore.
we're on the original bill.
So line 32 will be the language that the attorney is working on. We'll insert it right there,
Right,
and then we'll just move 32 on down.
right, it comes on down.
Okay, I'm
When
gonna
you
wait
add-
to see
When
what
you add a
it's,
subject C to it.
okay, I'm gonna wait to see what it sounds like.
If somebody points, he's going to
residency and the timeline for residency requirements. Okay. We wanted to make sure that they were residents of the state of Georgia and paying taxes, and that there was at least 2 years they had to be here.
Yeah, honorable.
Do y'all wish to address this?
Yes, sir, and GMA doesn't have any issues with this legislation, but just help them out. With the amendment that says such person shall comply with all of other provisions of this code section, and 16-11-129 says, it says domicile in that county or who is on active duty with the United States Armed Forces and who is not at this domicile of the state, but who either resides in that county or on a military reservation located whole or in part in that county at the time of such application. So it would refer back to that.
There you go, you just make a reference to
That's the
that
code.
section.
That's what we were looking for.
So, as he said, we might just refer back to the code.
Yeah.
That suit you?
You gotta follow the
Yeah.
other requirements.
Okay.
The last sentence, and if you look at the amendments, the very last sentence there, Mr. Bryant.
I'm okay.
But you don't need C.
Julius, do you have that?
Okay. That'll work. Now we're going to original.
All right. Well, that's the advantage about having so many lawyers in the room.
Thank you.
All right. Now, do we have a?
What was that code?
Yes, ma'am.
Mr. Chairman, I have another committee hearing. I was wondering if I could be
Oh,
excused.
okay.
You certainly may.
Thank you.
I hate it you're going to miss when we talk about the Uberizing, but
I'd kind of like to hear that.
Mr. Holcomb?
Thank you, Mr. Chairman. I don't want to wordsmith this to death, but we do want to get it right. And the only other thing that I would offer is to substitute the word armed forces with A capitalized and F capitalized, because that's the technical term in place of military throughout this. So it should
What
say,
line number is that?
it'd be on 23,
On the original?
yeah,
And 30?
24, 28,
That covers all
29,
of them.
30, yeah.
Yeah.
That's the technically correct term. Yeah,
And they'll-
both capitalized.
United States Armed Forces?
Correct.
And they'll take care of all branches.
That's right.
Good.
All right. Lights lit up over here. It looks like a Christmas tree.
Oh.
This is the appropriate time.
Mr. Chairman, I'd like to make a motion to do pass of LC 353025
Yes.
as amended. We need to do those amendments.
All right, we have a motion to move on the original bill, LC 353025. Do I hear a motion? Do I hear a second?
Second.
We have a second. Now,
Yes,
second
Mr. Chairman.
motion.
First motion would be to, throughout the bill, any place that it reads United States Military, strike the word military and replace that with armed forces with a capital A on armed and a capital S on forces. Do each amendment individually or all together?
Let's do them as a combined, so we just do it as a committee substitute.
Okay.
All right? Does everybody understand that motion? All right?
The second motion would be to strike lines 23 through 26 and replace them with the language.
The amendment as on, that we have.
Yes, the amendment as we have it on the paper, with the exception of our
Striking
previous
military.
amendment, striking military and changing that to armed forces. Then on the back, on lines, we would strike lines 29 through 31, and we would substitute those lines with lines 32 through 35 of LC 400599S. The code that she is referencing is on line 27 of the original bill. And that's where it references that all of the provisions of this code section, which reference back to the residential requirement. So that should be all the amendments.
All right, let's walk through it one more time to be absolutely sure we have got.
Okay, walking through the amendments again, it would anywhere in the bill that reads military or United States military, you would strike the word military, replace it with the words armed forces with a capital A, capital F. We then would strike lines 23 through 26, and again we're working off LC 353025. Strike lines 23 through 26, replace those lines with the amended language that we have, obviously with the exception again with the word military being changed. Then we would turn to the back and we would strike lines 29 through 31, and we would replace those lines with the language found in LC 400599S. The language found on that LC number on lines 32 through 35.
All right. Julius?
Line 23, we would need to add after we insert armed forces, add also or the Georgia National Guard in that bold heading.
Yes.
And then in line 26, I guess technically we need to strike line 27 up through license, since the end of what we are inserting into it has the same language. Well, try to get language. So if we're going to keep the sentence that starts with on line 26 that says such person shall comply, so I guess we would strike line 26 up into code section, and then leave that last section.
No.
Say such person shall comply with the other provisions.
Right. But then in the part we are inserting into it, we're going to strike that last line there from the amendment.
Yeah, you got a redundancy there,
Okay.
I guess.
Okay.
All right.
Just so Les Council knows, and we're on the same line, you do understand the reason that we were wanting it to say shall comply with all other provisions of the code section was to get in the residency requirement addressed elsewhere.
Exactly.
And that would what you're saying takes care of that.
Yeah, I'm saying if we insert the new language into it, we would have a sentence that says
Same thing. Okay.
So since the sentence is already in the bill accomplishes, refers back to the code section, and the part that we are inserting to the bill, strike that last sentence there.
Okay. Okay.
Vice Chairman Taylor.
Thank you, Mr. Chairman. I think we also need to go back and look at line 3 and 4, where it says without the payment of, and we need to take out without the payment of and put all or part of certain payment or fees. It needs to be corrected. It won't work right. I went back to the original. Thank you, Mr. Chairman.
All right. Thank you. All right. Now, does everybody know what we have in front of us?
I couldn't guarantee tomorrow I could quote it perfectly, but I would, sure I have several people could keep me straight, sir.
If this isn't perfected enough for you, I just don't know what else we can do. Do we have any other attorneys in here that would like to add anything to this?
odd or even day or
Any other wordsmiths? Any other wordsmiths that want to? All right. We know what's in front of us, and we have a motion to amend. We have a second. A second to amend. All right. Any other motions or any discussion on the amendment? All right. All in favor of the amendment, say aye. Aye. Opposed? The ayes have it. Now we're back to the original motion on the bill. Any discussion? What's the will of the committee? All in favor, say aye. Aye. Opposed?
Thank y'all. I appreciate all the work. Don't send me a bill, please. Thank you.
Quite welcome. Ladies and gentlemen of the committee, we have another bill that we've been wrestling with all session. It's a bill that Representative Wilkinson, who couldn't be here today, had brought forward, and this deals with a specific problem that he saw, and that's about people parking along the roadways, and I think this is mostly down in the beachfront areas. You know, we have wrestled, and you talk about wordsmithing, we have had more people that have looked at this to try to find language, and it all comes back to the same thing, this unique problem they have, that this language seems to be what's there. Now, I'm going to stop with that bill, and I'm going to bring up the other issue that I talked to. We got some folks here. I see some of the players that have been working on this most infamous Uber bill, House Bill 907. Now, I've got a few comments that I want to make to the committee, because I think that while a lot of times as we're doing legislation, you know, we get out on our own and we're trying to get things done, and the process is working. And it becomes obvious to me that outside of the players around this Capitol and people that participate, that we have a lot of people who don't understand how the system works, and that every piece of legislation dropped in is not an event but a process. Very few bills pass that haven't been scrutinized, they've been worked over to do a lot of things. I have, in the past, I have given my appreciation and gratitude to the committee members for tolerating a lot of the harsh emails and letters and a lot of the negatives that's been put out. I especially have given my thanks to Vice Chairperson Taylor, Representative Atwood, Representative Hightower, and others who immediately worked with this issue. So at this point, I'm going to give you an update and deviate from the norms, and I'll get back to Representative Wilkinson's bill in a few minutes. But I want to bring y'all up to date, and there's some people here that might wish to address some of the things that's going on. There has been a tremendous amount of negotiation with the technology transportation referral folks. And I'm certainly willing to, I'm going to make some statements, and if they wish to refute what I'm fixing to say, then I want them to feel free to. This has not been an easy issue to deal with. One is because from the get-go I had said that these are some this new concept in transportation was something that I had a very strong amount of respect for as a new way of doing business. Something that in rural Georgia, that these type of companies could possibly provide transportation. But I said from the start of this that my concern was the fact that Georgia policy that we have always, and for a reason, that we have always required criminal and driving background checks to folks who are for providing their services as a for-hire driver for the obvious reasons. The other issues that I had concerns about were the sales taxes and the insurance, the liability insurance question. Not so much from the standpoint of Uber itself. That business model of Uber is a very interesting model, and the fact that I don't think that everybody goes out and buys a black limousine or a black Suburban to provide those services. I think those are, quite frankly, limo operators who are using this technology as a way of generating business. Now, that being said, they're already regulated by the state of Georgia. Those Uber drivers, for the biggest part, already have, and I'm sure if not all, practically all of them already have a chauffeur's permit issued by the state of Georgia, which means they've already been scrutinized with background checks. The other business model, which was the UberX Lyft model, was the one that was quite interesting, a whole different variation. And that means that any one of us, if we want to sidelight as a driver, then we could do it. Never disputed anything that these companies said about they did their own background checks, because I think, quite honestly, that was part of their business model. They didn't want to have folks out there who might be a criminal, who may not have a good driving record. And in the process of this, and I see some of the folks here, and they might wish to address that, but they've been working on this. The other day, another faction came to bear, and that was some folks with the insurance industry. And I think that they might even try to get them to, if they're enticed, they'd like to address that. And the reason I'm saying this to the committee members is we have got 1 day left. We've got 1 day left to get this bill out. Now, I will tell you that this bill has some hurdles to climb. The biggest hurdle, and I have said this to the leadership, I will not call for this bill to be heard on the floor of the House unless there's a lot of the misinformation that has been put out is corrected for the members. I do not think that it is correct. I think that it would be a travesty to bring a bill out and people vote against a bill because it's been demonized, not on its qualities or the necessity, but because of the anti-campaign. I'm not going to get into too much about the anti-campaign, but it's been this has been a pretty interesting piece of legislation. 24 years that I've served, I don't think I've quite seen things get out of control with the social networking, with the companies who have their own database. By virtue of having you as an app, they've got your email, and the drivers and whatever have put out a plenty amount of information. I have friends who have the apps that's got emails from these companies saying they're trying to put us out of business. I think that at this point, the companies themselves, or the representatives for the companies, will probably say themselves, at this point, they understand that we're not trying to put them out of business. And I'm hoping that they'll stand up here and verify that. But my goal at this point is, I had told them a couple of days ago that they had 5 days that somehow this issue needs to be corrected in the minds of the public. When we have talking heads on the radio that's bashing everybody associated and putting statements, irresponsible statements out that we're trying to put people out of business under the disguise of public safety, that's wrong. That's a misuse of the airwaves and a misuse of people that are supposed to be providing some sort of intelligent discussion on issues. Now, at that point, I would like to bring this up and let some of the folks discuss this. I see a couple of parties. Mr. Bowers, would you like to, you and Mr. Snyder, would y'all like to address this? I mean, I see our insurance folks. And this they've developed quite a working relationship, but I'm very pleased to them. And I don't see the Lyft representatives here, but I will say up front that they have been also very cordial and coming to the plate to try to define some of these issues. I will say before I turn it over and let them discuss what's going on, there was something that I didn't realize until we got started, that one of the concerns of these folks were that they're in negotiations in dozens of other states about the regulatory part of this, and that their concern might have been, and I say might have been, that whatever Georgia did, that we might be leading the way So that was one of the reasons that we had opened it up, and we wanted to do any and all things to help promote while still addressing the problems of public safety. I'm going to let Mr. Bowers and Mr. Snyder address this, if they would.
Members of the committee, I just want to reaffirm what the chairman is indicating. We have had some, I think, very productive conversations even since the vote when you voted on this bill. And just to give you a flavor, and none of it is completely nailed down, but we have a number of items that I think we both agree on, and that obviously both Lyft and Uber would have to, are rechecking with their folks, because as lobbyists, all of us have to check with our clients at the end of the day. Let me just pull aside for a moment. You all remember who were at the meeting, the witness who was blind, who made some testimony at our hearing, and I think it affected all of us. And one of the things that we wanted to add to the bill, if there was a way to substitute with some of our thoughts and what we're doing, is he told the story about how we put in the bill already that if you're dealing with a transportation referral service provider, they would have to accept credit cards. But we obviously didn't go far enough. And he told the story about how sometimes he takes MARTA and he gets off and he gets into a cab, or he might get into a limo, and without a transportation referral service provider, and he'll go and try to pay with a credit card, and they won't take it. And as he indicated to you in his testimony, he can't tell the difference between a $10 and a $5 or $1 bill, and he got ripped off. I mean, it'd be $8 and somehow three $10 bills, went out of his pocket. So we added to the bill in a substitute that taxi cabs and vehicles for hire shall accept credit cards in payment for transportation services to address his issue at it. In addition, we have worked, fairly intensively to, hone up the definition of transportation referral service provider to cover the example where Lyft, which does it by donation that you heard in your testimony, as well as UberX that does it for hire. And we cleared up that definition, and we're obviously looking at. We addressed the preemption issue again, and we are trying to make sure that both Uber and Lyft would be able to do work at the Atlanta airport. And that's why we're looking at additional language so that they wouldn't be precluded from being able to pick up passengers at the Atlanta airport. There's already something in the presumption law on limousines that although the state law controls, the airport can issue a permit, and we wanted to make sure there was language that rideshare situations could get a permit there. In addition, we took out one section on driver training because we made sure and we verified with Department of Public Safety that there is not a driving training program required for limousines, so we were not going to require it for the transportation referral service provider drivers, although the City of Atlanta and other local governments on cabs, some of them do have training program, but we were not going to do any different standard for the referral services that we did for the limousine carriers under present state law. In addition, we wanted to make sure that we were absolutely clear that on the issue of a fare, that there was the whole issue of pricing was made very, very clear. Both limousine carriers, UberX, Uber will do an unmetered fare that's based on, could be any one of the following factors: distance, flat fee, base fee, waiting time, stop fee, event pricing, demand pricing, or time. And that is a very critical distinction, so it gives everybody the maximum ability. You all know that Super Bowl weekend, the rates are going to be a little different than they are during regular times. Prom weekend is going to be a little different. The point that the Uber witness indicated that there are times where there is simply a greater demand, and therefore during that greater demand period the rates may change. But we all agree that the part of the bill that we all talked about last time, that a passenger will have notice of how much they're going to pay before they get into that car and that ride starts. They'll know the factors that they're being looked at. So we felt that that was very transparent to the public. I can say collectively, and it's become more crystallized in our thinking, that the sales tax is very problematic with this industry. That's referral service providers, limousine carriers, taxis. We're only one of 5 states that actually require a sales tax on a fare. My personal opinion, I won't speak for Uber, won't speak for Lyft, I think the industry overall has a great deal of noncompliance, and it's not right that companies that pay their sales tax end up are at a competitive disadvantage to those people who don't, and that goes across all the models. And that's why the part of the bill that has the study committee is so critical to sit down and come up with a better system, so that if Mr. Bowers and I are honest operators, we don't want to be at a 7 or 8% competitive disadvantage every single time we quote on transportation services to be provided. I guess in closing, the key part is that I've been around here long enough. My good-looking blonde hair turned gray already, but I can just say to you that I've seen what happens when a bill that has a lot of merit gets a bad number, and I think Representative Powell said very clearly, when you try to stir up a lot of misinformation, it takes away from the merits. So if there is a possibility that this bill can, and the work we've begun to do on it, can be worked into another number, I know it sounds ridiculous, but I've seen the impact that can have. But I think we're working in earnest. I've had conversations today with both Mr. Massey, who works with Lewis, with Bruce, and also with the folks from Lyft. And, we're getting some very, very, I think, positive feedback in the sense that we're going in the right direction to make sure that the public has the full benefit of all the options when it comes to transportation services, and any help you can do in that regard would be appreciated. And I'll answer any questions. Go ahead. And Bruce is going to supplement. Go ahead.
Members of the committee, Mr. Chairman, my name is Bruce Bowers. I represent Uber. First, I want to apologize for my attire. I did not intend to be speaking. I can't apologize for your attire, Mr. Chairman, and I don't want to get cross with you any more than I already am. But apologize for that. I did not intend to be speaking. And I will tell you, and perhaps other lobbyists out here can say the same thing at times, that our job isn't always just lobbying legislators, what I like to think of as lobbying up. Sometimes we have to lobby our own clients, which is lobbying down, if you will. And I will tell you that it has been far more enjoyable to lobby up than it has been to lobby down. And as difficult as it seemed and as cantankerous as it's been to do that. And I guess maybe like Forrest Gump said, that's all I'm going to say about that. We've been working very hard, largely through the good offices of the chairman and Les here, to try to get to something that works for everybody. I believe we're very, very close. I agree with everything that the chairman said earlier. It is our very strong desire that that there is no disrespect to the committee, to any member on the committee, to any member who's in the audience who isn't on the committee, or to any other member of the House or the Senate. I will say, and I don't say this as an excuse, there are a lot of folks who are interested in this who often lack a lot of self-control, and we have not had a lot to do with most of those folks. For example, I was as shocked at some of the testimony and did not know the individuals who gave the testimony here the other day. So again, that's there are things I wish had not happened coming from a number of different directions here. As far as the bill goes, we're getting there. There's been a lot of work. As I said, Les has been doing it. I do believe we will resolve the issues related to the public safety, as well as some other issues. And as Les said, I'm available and open for any questions anybody has for either regard to the bill or anything else.
Just a quick question, Mr. Chairman. You said that you were working on some language in regards to being able to operate at the airport. Going back and reflecting back to the guy that came to represent the taxi companies of the city of Atlanta, one of the things that he talked to us about was the fact that some of these folks are picking up fares that are not going through the proper system, both at the airport and other locations. Have we had conversations about that and where we are with it?
If I may first, and I cannot speak for the ride-sharing industry. I won't even try to. I can speak for my client, Uber. Uber's platform, its software system, does not permit the kind of staging or anything like that. If someone, it requires someone to go on an app and say, I want a ride. So in order for that to happen, there has to be, a client who's going on, and if they find that someone is staging, they will kick them off their system. And I can provide you their policy as regards to that, if that would be helpful. So the Uber X drivers, who are the rideshare drivers about which we've had the most discussion, they cannot engage in that kind of behavior and then receive the kind of ride that I think some of the cab companies are worried about. So as far as I'm aware, Les, and correct me if I'm wrong, the language, and we've said we're working on language that deals with the airport, it's to make it clear that there can be no staging other than of taxi companies that are licensed by, in the case of the City of Atlanta for that. We have no desire to stage or have our drivers be there. That's contrary to the business model of UberX.
And I would just I would just add to that, Representative Blanton, that because of the language we have in the bill, as we've begun to negotiate and we've included as of yesterday, it would allow, I'm sorry, let me back up. Right now, anyone can drop somebody off at the airport. There is no restriction as to that, whether it's a cab, whether it's a limousine, whether it's your mother or your father, anybody can drop somebody off. It's the pickup that's the issue. You cannot pick somebody up at the airport unless you have that airport permit. That airport permit not only requires a whole separate bureaucracy at the Atlanta airport on the city level, but it also requires a permit and a background check on the federal level. So this would allow both the UberX driver, the Lyft driver, or anyone else either under a transportation referral service provider or under a traditional limousine carrier, that is, they would give them the pathway to be able to get that airport permit. So again, it's on a level playing field. The taxi would be able to do the same thing. So, and again, this bill is comprehensive enough that if somebody wanted to do a model of a transportation referral service provider using taxis, that could be done under this bill. We're not leaving anyone out.
I guess my concern is you said that they would go through the regular process for permitting to be able to drop off at the airport, but you didn't quite address the issue or the concern that I have with staging and picking up riders that have not been pre-booked by way of the app.
Well, in the bill, if in fact if you do that, then you are violating the precepts of this bill. Just as a limousine carrier, if I did that, I'd be breaking the law as it presently exists. You cannot do anything other than, Ms. Bauer is correct, other than prearranged transportation. And whether you prearrange transportation using an app because you know how to use technology, or you're a Neanderthal like me and you pick up the telephone and say, please come get me, it's all prearranged, and we have not changed that in any of the models. Taxis are on demand, the hailing, and the other one is prearranged transportation, what we're doing. Now, if a referral service provider wanted to use taxis, they could do that on the hailing basis in this bill. Okay? So at the end of the day, we are again, everything can exist, they're just all properly registered and set forth.
And as a practical matter, a taxi cab, as you know, they have a line at the airport where an UberX driver cannot get in that line.
Can we get in the line?
He's not able to get in the bullpen or whatever the expression that's used. He can't get in there to be a part of that. And if he stands outside of the airport at the passenger pickup area, he's as likely as any of us who have been down there to get the Atlanta Police Department to come over and do everything but start pushing on the vehicle to get you out of there. So just as a pure practical matter, I think that's less of a practical concern than it might be, kind of a regulatory concern. But I do believe that this resolves that issue, and I do know that, in fact, that the UberX model does not permit the driver to be at the airport and to receive a fare as a result of that, or a ride.
Mr. Lunson.
You alluded to the problems with sales tax. Could you get into that a little bit?
Under our current law, we are one of the few services in the state that actually has sales tax attached to it. Most of the time, you all know that sales tax usually applies to products. So there is a 7 or 8% sales tax on fares. A number of years ago, we had a bill in the legislature to try to address this, and Representative Prowler was gracious enough to write a letter to the Revenue Department and ask the million-dollar question was, how much money does the state currently collect in sales tax from fares, from taxis, limos, and other transportation services? The main answer, and this is no criticism of revenue, but the main answer is we really don't know. They don't know. The best that they can come up with at this point is about $1.5 million. If $1.5 million is what's being collected, and there's over 6,000 vehicles between taxis and limos, you all can understand that nobody could make a living across 6,000 vehicles if you're only collecting $1.5 million in sales tax. So either one of two things is happening. Either there is serious non-reporting, which I believe, and then we have the people who believe they should follow the law and do report. And therefore, they're at a competitive disadvantage to the people who don't. And it's just very easy. Now, the transportation referral service providers would properly say, if I was Mr. Bowers, say, look, we use credit cards. We can easily, we account for all the business we do. Somebody else may just take cash, so it's not so easy. But at the end of the day, this is a bad model. I mean, if you're one of 5 in the entire country that does this, there's a better way to do this. And I know we've talked about perhaps the use of a decal or something to supplant this sales tax so it's a level playing field as far as payment. I know none of you would want to say, we want a system where somebody can give somebody an automatic 7 or 8% pricing advantage by not following the law. And there are very few audits done. It doesn't happen very often. Now, yes, if we make enough noise, maybe somebody will be audited. But at the end of the day, we're really about, and I know Mr. Bowers shares this concern with me, we're about having a system that people can easily comply with, that's transparent, and that everybody then can compete in the necessary, business models. But I'm sure there are taxi companies, limousine companies, other folks who are just not complying. And that's a big problem. And it's not right. It's not fair for anybody who's trying to do business correctly. And the bigger you are, the better chances you're complying. And then you have a lot of other people that say, well, I can undercut the business model. And we don't want to do that. And we have gone out of our way to accommodate the issues of getting people out on the road to drive, addressing the safety concerns that Representative Powell had, and at the same time make sure you got a safe driver, proper insurance, a safe vehicle, and everybody's paying their fair share of taxes. That's really what this bill is all about.
And if I may, there's actually a secondary problem, which in some ways is as important. Really, when you call a cab or when you engage a new UberX driver, there's really 2 separate business transactions going on. There's the dispatcher or the taxi company's portion of a fee for arranging the ride, and in the case of UberX, there's the corporate portion of that, the part that Uber gets. There's a pretty high level of uncertainty under the Georgia law as to whether that is taxable. And then there's the primary thing that we think of with a taxi is the actual ride itself. There's not much question about whether that's taxable. In fact, most fares, taxi fares, I believe it is built into the fee. So one of the reasons that I believe a study committee makes a lot of sense is there's really 2 business transactions going on, and there's a fair amount of openness as to, or a fair amount of question as to how and what the level of taxation for those 2 different types of transactions are in 2 different fairly different models also.
Yeah. And that's further complicated by the Revenue Department apparently informed Representative Powell and myself that there was a case that went to the Georgia Supreme Court about 5 years ago that basically said that a dispatch cab company, a dispatch company that basically dispatched cabs, would dispatch trips to numerous independent contractors who were taxi drivers. And come to no surprise, there was no sales tax being paid. And it went up to the Supreme Court, and, you know, the question was, who owes the sales tax? Does the driver who got the fare owe the sales tax, or does the dispatch? Are they responsible to make sure it gets collected? And the decision was that they both owe the sales tax. And then the problem is, I've had cases, I can tell you, where limousine companies have made arrangements with a hotel for the hotel's guests to be picked up. And at the end of the day, what happened is that it got put on the person's bill, the hotel bill, for the limousine ride. And the Revenue Department in a number of cases have said the hotel as well as the taxi company, the limousine company is responsible to make sure the sales tax is paid. So again, I think we both feel that there needs to be a little better system to address it.
That's all, Mr. Chairman.
Mr. Glanton. Beg your pardon? We got a few minutes.
Les, thank you. I'm trying to understand something. Help me understand. If I understood you correctly, you said that it's unfair for folk who are paying the sales, reporting receipts, and folks who are not, and you suggested that either we eliminate that sales tax or come up with a system that would get everybody in the system paying taxes.
In compliance.
In compliance. But wouldn't that apply as well to taxes, sale receipts across the state? In 2008 and 2010, I believe we put forth some legislation that authorized another 8 agents at the Department of Revenue just for this reason, to try to go after those people that are not paying receipts. So how would that be different than what you're talking about? Because if I understand you correctly, you may be suggesting that the entire state, because we can't collect 100% from all companies in the state, that we just eliminated it.
Well, this would be my suggestion. I have found in the research that I have done that in the states that do not have sales tax, the other 45, as you say, your options are no sales tax at all, we're just going to forget about it, or, and one of the suggestions that was in the earlier version of the bill, that we go to a system where there is a sticker that would go on the car, and it would cost a certain amount of money. And that could supplant the sales tax. And then it's very easy for any enforcement person, whether they were police or whether they were Revenue Department or whatever, if the sticker's there, it's been paid. If it's not, it hasn't been paid. Your audit function is much easier, and you really shortcut it, that you can find immediately who has paid and who has not. You're familiar, obviously, with the amusement machines or whatever, but we took the sales tax off the gross receipts on amusement machines, and we put on the stickers, and enforcement and the auditing went up 150%. All of a sudden, there were 150 more people in the business than we ever thought we ever had. Because when an agent walked into a facility, you look at it, stickers are there, they paid the tax. Stickers are not there, they haven't. It was easy to tell. And what we're saying is, if the cars are out there and a sticker is there, you can tell immediately whether somebody's in compliance.
And again, I'll be very brief.
Yeah.
Again, two different issues. One is you've got a lot of cash transactions going on.
Right.
And I'm not throwing rocks, but by and large, well, not by and large, a lot of taxi cab transactions or cash transactions, which you've automatically got a difficult issue there of monitoring it. The legislation here would require cabs to accept cards, but there's still not a mandatory obligation to take cards.
Right.
So from the beginning, you're talking about a cash transaction, which is hard to monitor, which lends itself to some other system of making sure that there is some form of revenue tax on the system, but it's hard to measure on a transaction by transaction basis when you've got a high level of cash pay transactions.
All right. If y'all would, if there's no other questions at this point, if y'all would step aside, because we've got some another group of folks I think that might like to have just a word for the committee about possible concerns that they have. And I do want to thank both of you gentlemen. And I've actually got quite fond of you, Bruce.
Hey, good morning, Mr. Chairman, members of the committee. My name is Stacy Freeman. I'm an attorney in private practice here in Atlanta, and I represent the Property Casualty Insurers Association of America. PCI is a national trade association, approximately 1,000 member companies. They write property and casualty insurance, and their members comprise approximately 46% of the private passenger automobile insurance market. I'm not here to address the safety issues and the business-to-business concerns. I'm only here to speak towards the insurance issues, and specifically with regard to the ride-sharing activities. So limo services, taxis, referral services, or other issues are not what I'm talking about. I'm talking about use of private passenger automobiles covered by private passenger auto insurance that are being used for ride-sharing activities. There is a common exclusion in private passenger auto policies. It is well accepted by the courts and it's well known, and there's an exception for livery service, cars for hire. So what that means is there's no private passenger automobile liability coverage, comprehensive coverage, collision coverage, or uninsured motorist coverage when a car is being used for livery services. And I think a lot of times the question is asked, well, you make sure folks have insurance. Yeah, they got insurance. That's different from having coverage for what you're doing. And the issue is, as I see it, or PCI sees it now with the existing legislation, is when it was first introduced, it said primary coverage would be provided in some details. Now the language reads primary or excess must be provided. Well, there's a lot of different phrases you can use for excess. You can call it surplus, you can call it drop down, you can call it umbrella, you can call it everything. If it's anything other than primary, generally what that means is that excess coverage is following the primary coverage. So if the primary covers it, the excess covers it. If the primary excludes it, the excess excludes it. So if the primary policy has excluded liability for a certain circumstance, then excess generally isn't going to apply. You've also got other concerns in that generally excess coverage doesn't provide a duty to defend. So primary coverage does. You can litigate over whether there's coverage or not, but excess generally doesn't do that. Now there's a variety of forms. People may refer to it as drop-down coverage. So you've got an excess policy, primary coverage goes away for whatever reason, that excess will drop down and kind of take its place. Well, that's not what the current version of the law says. It may be being voluntarily provided by some ride-share services. I don't know. But as the law exists now, or as the bill is proposed now, it simply says excess. And let's assume, for instance, that excess coverage does apply. You still have a situation where the drivers in this circumstance, they don't have comprehensive, they don't have collision, and they don't have uninsured motorists. So if somebody goes out, buys a new car or a late model used car to do this, they've got a loan. Anybody that's had a loan agreement with a car knows that the lender is going to require you to have comprehensive, collision, whatnot. So you have an accident, there's a possibility there's not going to be any coverage. Now that's a distinct issue from the liability concerns, but just wanted to raise that issue. So I'd be happy to answer any questions, Mr. Chairman.
Vice Chair.
Thank you, Mr. Chairman. As we've gone through and examined this bill, this has been one of my concerns from the very beginning. As an insurance professional, having folks not truly understand their coverage. And one of the things that I have requested and discussed, I don't think it really ever went anywhere, is to at least have an assignment so that the folks that are doing the referral service would have to be notified of any change. They need to see these policies. They have to know if, in fact, there is coverage. We've made a lot of discussions here, but this committee is to address issues of public safety, and this is public transportation. We can call it by any name you want to, but it is public transportation, and accidents do happen. And part of our responsibility is to see that there is coverage for the unsuspecting person that could be involved in one of these accidents. So I appreciate you bringing this forward. It is something that is important to the issue. Thank you.
Yes.
Thank you, ma'am. Let me be sure I think I understand what we're saying. So even though in the discussions that we've had over this bill, from the get-go, the only thing that I had spelled out was my concern that there had been background checks on drivers, criminal and driving, insurance and sales taxes being paid. Mm-hmm. So when we were discussing this, we discussed a little bit about the liability insurance coverage, and I think I'd said it clarified earlier. I don't think that the problem is with that original business model of the limos,
Right,
that are out there, but the other one. So am I to understand that when we hear that, it's been said that they have $1 million umbrella over and above? So if I understand what you said is that it's your belief that if they don't have a commercial livery liability policy, then the umbrella wouldn't be in effect either.
that is quite possible. I've not seen the policies, but nevertheless, even if they did have a policy that would provide that coverage, it's just voluntarily. But yes, you're accurate. Generally speaking, private passenger auto has this exclusion. Generally speaking, excess follows the primary policy.
So someone who has signed up and they're a driver, if they don't have that policy, or mom and daddy doesn't have the policy on the vehicle, what would be the effect if they're running that livery? And I'm getting to gather that all of a sudden, if there's an accident, somebody's going to be out of a car because there wasn't any coverage.
Very likely.
Could be possible medical expenses that aren't going to be covered and the such. What about that same driver, say that they're not hauling a fare at that particular day? Would that coverage even be null and void if they just had an accident, say they were going to pick up a livery?
That's going to depend on the individual policy of each carrier and how they interpret it. So you've got ride-sharing services and activities. You've got being engaged in the livery business. So I would say you've got a bright line if somebody's in the car and paying you to drive them. And you move a little way from that bright line when you are dispatched or matched, whatever the term is, that you are going to specifically get someone. And a little far from that, you would have the situation where you are on duty or logged in. You are in a neighborhood or a vicinity where you're saying, I am eligible to pick up passengers. Generally speaking, I think you're going to hear an argument that that entire situation is a commercial service that is being provided. And private passenger automobile insurance is not intended to cover commercial activities. That's why there are distinct commercial policies and they're rated differently for the according risk. So to answer your question, I don't know that there is a bright line specific on that issue.
Very good. Any questions, Mr. Freeman? Mr. Bowers, would you like to?
If I may, and I can speak again for other transportation referral services and other business models. Today, Uber's insurance policy is a drop-down policy, and in the absence of coverage from a personal vehicle, it would cover from first dollar there, the coverages. And in addition, and I would suggest this is appropriate for the legislation, the issue that Stacey raises as to whether there is coverage while the driver is logged in. Uber believes that is appropriate for the legislation from the time someone is logged in until they're no longer logged in, that there be commercial coverage for that entire period of time. So, that's in the legislation again to cover the entire period of time.
Yeah, thank you. Any other questions? I want to thank you for taking time to come here this morning, and thank you for your participation over the last few days of making an issue of this.
Yes, thank you for the opportunity. Thank you.
Committee members, the purpose of I want to discuss this and then move on to the next phase of this is that we may very well be visiting this bill. I think that from the discussion that you have heard here this morning that, the total anti-feeling that came out about this bill, now there are some participants into it to understand why there's a need for legislation on this. It wasn't any of the intentions to put anybody or a new concept out of business or anything like that. It is, in fact, a public safety issue, something that concerned me. There has been a lot of misinformation now. For the sake of the committee, I want to give you my scenario to what can happen or might happen or may not happen. I have talked to the players involved in this since there has been so much negative publicity that has put out that has demonized the name of 907 as a House bill. I don't think that it would be fair to even attempt to put this on the floor of the House unless there has in fact been some reconciliation of the misinformation that's been put out. I have members of the House who have told me up front that the ugly emails that they've gotten, some of the members that were basically threatened to the point they took their names off the bill. They just, this is a rare phenomenon of a bill. The talking people who are on TV or radio that's supposed to be semi-intelligent that never even read the bill or participated. I could call their names, but they don't apparently read the bills, and they're not news reporters. They're entertainers. But that's the type of stuff that has disrupted this process that's involved in here. So I will tell you that I'll go back to what I'd said originally. I had told the players that are involved in this that if there is sufficient effort on their part to clear up the misinformation that has been put out there, to all those people who have been, for no better term, or that I've invented a new term, Uberized, that if they see the necessity of why we're trying to do this for their public safety, then I will approach the leadership of the House, and if the leadership of the House sees fit with me at that time, that we may very well take this particular bill that we are not acting on this morning, and we might use this as the vehicle with the permission of the author of this bill. I would tell you that it would be quite extraordinary because we would have to have a called meeting of this committee. To do so, that means that the Uber folks, the Lyft folks, the other folks in the committee itself, that we'd have to all be in agreement to that. We'll make the paperwork available of what they've done so far to the committee members for y'all to look at tomorrow and through the weekend, so that if y'all see any changes, because if y'all have known anything else, there's one thing, and I'm very particular that everybody has a right to know what we're doing, and I want to hear your comments. So we're going to make that available, and I want to thank Mr. Bowers, Mr. Snyder, Mr. Massey, wherever he is today, Mr. Marsh with Troutman Sanders, I believe. Oh, I'm sorry. Have you been there the whole time? Would you like to come up and address this?
I'm good, Mr. Chairman.
Good deal. But, I want to thank them for everybody coming to the table. They've identified some of these problems. For the committee members, if y'all continue to get any threatening any threatening phone calls, if you'll call and let me know, then we can, I think I see somebody with a GBI there in the back. As a matter of fact, you need to come to my office after here. There's a threatening phone call. Somebody's threatening to do bodily damage to me. So, it's been an unusual bill, to say the least. And do we have any other comments? Madam Vice Chair?
Thank you, Mr. Chairman. It's actually some wording that has to do with the people that are driving the vehicles in the bill. The last version I saw, it said when they're driving their personal vehicle. Well, I've come to find out that some of these are not their personal. It's mom and dad's vehicle they're driving or grandma's vehicle. It's not actually titled in their name, and I just want to make sure that's corrected or worded in such a way that it will be included in the bill.
Yeah.
Sorry, I need the bill.
We're going to, now, do y'all have a copy of y'all's handiwork available? Bruce?
Les, I believe, has the master copy.
Would it bother you, and Reagan, I don't want to leave y'all out because y'all have been very good to work with Lyft. Would it be troublesome to y'all that we get the most recent update electronically so that it can be distributed to the members. Because before they cut out, I don't know if any of y'all are going to be in town tomorrow or you're going to cut out after today, but I'd like for y'all to take a copy, to look at it, make this available to y'all, because if we have to do something, we know Monday is going to be a stressful enough day, but it'd have to be we would have to move to amend, have a special call meeting, and I see another hand that's going up.
Yes, sir, this is, it was from the property insurance, property and casualty of the city. Well, I remember back while I worked with the DAPS, against the Domestic Claims Association, but we want to be sure whatever draft is being circulated, that does include the insurance concerns, and if not, we'd like opportunity to get that information.
Be more than glad to. You know, I love my folks from the insurance industry. I know you do. I know you do. But love to get y'all a copy. I'm going to, if the committee members would, we'll make, have we got copies of the office of this? I think we do. One. We'll go up and make y'all a copy. We'll try to get it electronically so it can be sent out into cyberspace. For all of those 10,000 people who have put the profane verbiage next to my name that sent these emails, if they'd like to get a copy, I'd like it to be somewhere where they can see what's out there. And maybe we can correct something, because I do think this is a very serious issue. Is that your button?
Yes.
Oh, I'm sorry. I'm sorry.
Mr. Chairman, I'm just trying to, I'm hearing call meeting. I just need to know how to make my plans here, because we have.
We're going to make you a copy of this, and it'll be up in the office. You got to get to another meeting.
No, I just got to get like 15 pine trees out my yard from the ice storm.
This meeting,
and I just want to know if you're going to have a call meeting tomorrow or Saturday.
No.
Okay. Thank
Not
you.
just no. All right. That being said, this meeting is now adjourned.